Well, Alvin Bragg was the DA in the Trump trial. He was out to get Trump.
At the AG's office, I held Trump accountable for his misconduct with the Trump Foundation. We did the Trump University case. We sued his administration more than 100 times since this DACA Muslim travel ban. I will hold him accountable by following the facts where they go.
Clearly, Loni, this was unethical.
That was a tainted position to take. He's biased, and that's not what prosecutors are supposed to be doing, right? You're not supposed to say, I'm going to go after somebody. You're supposed to say, what's the evidence? What are the facts? And then determine it from there. He didn't even look at the investigation before he did that. He was still running for DA. So once he then became DA, he should have not been involved in the prosecution if there was one at all.
Now, the lead prosecutor on this case came from where?
One of the lead prosecutors was a DOJ attorney, prosecutor. He had left the office and had joined the state prosecutor's office in December of 2022, and this indictment came in March of 2023.
So that's a step down.
I would say federal prosecutors would see it as a step down. Yeah, they see themselves as here versus state.
So they come from Biden's Department of Justice, steps down to a state position as a prosecutor, and then is in the case against Donald Trump.
Yes, he's one of the lead prosecutors.
Okay.
But for people who say that this was, a Biden investigation, we do have to point out that the Southern District of New York, which is run by the U.S. Attorney General picked by Biden, right? That federal court chose not to prosecute this case. Those prosecutors looked at, and they are the most aggressive district in the country as far as prosecutors. They looked at this case, they investigated, and they chose not to file any charges.
Right. In fact, Bragg looked at this earlier and decided not to prosecute it.
Correct. And his predecessor looked at it and never filed any charges.
Yeah. And the statute of limitations had run on both ends of the charges in this case, but they put them together, linked them up, and figured a way to breathe life back into them to go after Trump.
They literally revived them. That's
okay.
Correct.
And has that ever been done against anyone else in the state of New York?
A state prosecutor in New York has never done that using a predicate crime of a federal election charge like they did in this case.
Okay, so no one else in the history of New York has ever been pursued under this set of circumstances except for Donald Trump.
This specific way, that's correct.
So they breathed life into dead charges, brought them back to life, used them to go after Donald Trump, and it's never been done in the history of New York except against Donald Trump.
That's correct.
That's interesting. Go ahead, Ron. What do you want to say?
Let me address this issue just so that we have it clear. The statute of limitations had run on the charge of falsifying business records. To enlarge the statute of limitations, he had to allege that those records were created to conceal or commit another crime. The only other state crime that he alleged was, let's call it election interference. It was paying her to influence the election. A, that wasn't a crime, and B, it was time barred too. So he put two time barred claims together, one of which was wrong as a matter of law, the election interference one, and said, all right, now I've got a statute of limitations escape hatch, let's go. That was wrong.
But the New York law allows them to do it, right? I mean, that's how they were able to do it.
Yeah, but it was a big stretch to evade the statute of limitations. As I said earlier, they were cobbling together statutes in an unprecedented way to create a crime where none existed and to escape limitations.
And they've never done that before.
The one part of it, using the federal election law, they have filed falsified business records before. They've filed it with predicate crimes before. That's all been done. But so the falsifying of the business documents, as you said, the predicate crime, the second crime to make it a felony, was this state election law of interference with an election, which only happens if it's done by unlawful means. And what they then identified as three of the options for unlegal means, and yes, this is very confusing, this is why it's so hard for the jury to understand, there was tax violations, there was this federal election violation, or there were more falsified business documents. That is what the jury had to go through to get to whether he was guilty or not.
Former President Trump was just saying, voters don't have a right to know what candidates' skeletons are, and if they can keep their skeletons hidden, they're not committing a crime. This is not about morality, it's about legality. Everybody puts their best foot forward. Every politician puts their best foot forward. They don't come out and say, I've got a brother that's an idiot. I've got a this or that. They don't lead with those things. We all know that. It's not a crime to have an NDA or pay hush money, which sounds smarmy, and maybe it is, but it's not illegal. You talked about skunks in the jury box. What do you mean skunks in the jury box?
Well, a skunk in the jury box is evidence that should not have been admitted. And in this case, there were several things that stunk because they were skunk-like. The first stinky thing was that Michael Cohen had pled guilty to a variety of criminal charges, one of which was violating the federal election laws by paying Stormy Daniel. That was utterly inadmissible for the purpose of using it as the prosecutors did, which was to say, well, if Cohen did it, so did Trump, because Cohen was paid back by Trump. So they put it in evidence saying, this is a legitimate thing for us to use as prosecutors because it undermines the credibility of Michael Cohen. But the prosecutors were vouching for Michael Cohen. They were not trying to undermine his credibility. They were trying to make the jury believe him. The judge let it in, and the prosecutors then abused it by saying what I just said. Well, if Michael Cohen violated the federal election laws, and it's an established fact, said they argued, that he did because he pled guilty to it, then so did Trump. That was a big skunk, and the judge tried to take the smell away in the jury instructions by saying, Cohen's a guilty plea doesn't mean Trump's guilty. But the skunk stink was still there after that instruction. You can't unring that bell. That's one. Two, there were these other tales of hush money payments, one to a Playboy centerfold, one to a doorman, to keep quiet stories about Trump that were salacious and embarrassing. The judge shouldn't have let those in. He did, but they had no probative value. This is a question about falsified business records. What does Trump's engagements with a Playboy centerfold or whoever the doorman was talking, what does that have to do with falsified business records? Nothing. I think nearly any judge would have kept that out. This judge let it in, and it stunk.
And didn't this judge also say to Trump, if you take the witness stand, I'm going to let them cross-examine you about E. Jean Carroll and defamation claims and the contempt charges and a whole lot of other things that had nothing to do.
And the $450 million civil verdict that Letitia James got. The judge said, you better not. If you take the stand, Mr. Trump, I'm going to let them at you on stuff that hadn't got anything to do with this case. Trump didn't take the stand.
Although he didn't say you better not. You know, a judge can't do that. He gets in trouble for saying that.
Well, that was a clear message